I will introduce our panelists who have different areas of expertise, depth of expertise, and experience in the real world that is relevant to the topic today. Our first speaker is Professor Chris Morgan. He needs no introduction to the students. But he is, as many of you know, in his scholarship, an expert on Russian approaches to international law and the geopolitics of Russia and its near abroad. So it's interesting what this thing called Russian net is all about. And then we'll hear from Professor John Barrett, your constitutional law professor, our resident legal historian. But for the purposes of our discussion today, maybe some of you know or maybe you don't know of his past experience as a member of the Iran-Contra Independent Counsel's Office. And finally, and perhaps most significantly, we're really honored to have with us Philip Allen Lacavara, who was former counsel to the Watergate special prosecutor. So I'm going to read a little bit of his biography for those of you who've only seen him on CNN and MSNBC and some of his other recent appearances. He's held lots of positions in public service, including serving as special assistant to then Solicitor General Thurgood Marshall, special counsel to the police commissioner of the NYPD, and later as Deputy Solicitor General of the United States in charge of the U.S. government's criminal and national security cases before the Supreme Court. And he served as counsel to both Special Prosecutor Archibald Cox and Special Prosecutor Leon Jaworski. And some of you may have read the case. If you haven't heard the oral arguments that are available on the Supreme Court website, he argued the Nixon-Tate's case before the United States Supreme Court. And that's the decision that ultimately led to the call from your readings to the President of Nixon's resignation. So it goes without saying, he's widely sought as a commentator. I got to know him in the context of a panel on ICC arbitration rules. He has a breadth and depth of real practice experience, but also a teaching experience, and we're really honored and delighted to welcome him to St. John's for the first time. We're really, really pleased that Mr. Lacavara could be here. So with that, I'm going to open the floor for Chris Morgan's remarks.
Thank you. Thank you everyone for coming to what we hope will be an interesting conversation, and one really started by you, the students. What I'd like to do to start off is really to frame the fact pattern, or frame a fact pattern. So consider this: a country facing a major election, but an outside power steps in, and in stepping in, it has decided to undertake active measures to affect that election. It promotes fake news. It uses money to buy off opinion leaders. It puts money into the hands of politicians to try to affect how the election will go. It works with different groups and sort of tries to bring it under its wing in terms of essentially taking the election and making it go in the way that this outside power wants it to go. And all of this is within the frame of setting up news stories that have perhaps very little relation to reality. And of course, what I'm talking about are the actions of the CIA in 1948, which is when the first sort of start of the modern CIA, the start was actually one of the first operations of the CIA itself. And the reason I mention this is because this is going to affect what I'm going to be talking about in a few moments, which is some of the issues of why. Why might Russia have chosen to act in the way that it seems to have acted in the 2016 election? Because a lot of the discussion is going to be about Russian perceptions of the U.S. and how the U.S. acts, as much as our own perceptions in terms of what Russia may have done or how they may have done it. So what I'd like to do really for the next few minutes is to just sort of open up a few different areas of conversation that we'll talk more about really in the discussion. And those are on the tactical uses of disinformation. What is new about the current story? That is, what I just described is that this is an old story. I think that there are some things that are new. What is new? And why are they new? And finally, to say a couple of words about law and clandestine operations and what are the possible next steps. So first, in terms of tactics, as I've described, and as should be no surprise, the use of disinformation is nothing new. It's really as old as espionage itself. But the way in which we've seen disinformation be used in the modern world, particularly since World War II, and really since the 1970s, has been focusing more and more on an attempted use of psychological operations. That is, attempts to try to change the decisions that are made in a foreign country before they even realize that that's what's being done. To quote from Valery Gerasimov, who's the chief of general staff of the Russian Armed Forces, When he was discussing the lessons of the Arab Spring, he wrote that the role of non-military means of achieving political and strategic goals has grown, and in many cases, they have exceeded the power of force of weapons and their effectiveness. So one of the key things in terms of thinking about modern information operations is that countries have realized that at times, these are actually more effective operations than using force of arms, that you can get to results that you want to through the use of psychological operations, through the use of disinformation. Commentators who write about Russian military doctrine have noted 8 particular components that they view in Russian doctrine. Those include social control and social maneuvering, trying to influence society, the use of disinformation and the fabrication of information, and information manipulation that's all related to information operations trying to leverage its ends, and finally lobbying, blackmail, and extortion of desired information. As one student of Alexander Dugin, who is an influential Russian writer, had said, those who understand the net code manage the processes, the motivation of ethnic groups, and entire populations or countries, and foment conflict for their own purposes. This has sometimes been called a theory of reflexive control. That is, once again, you're trying to get a reflex from the counterpart. You're trying to get them to act in a certain way without them even realizing that this is what you're doing. So what's different now? I would say that there are a couple of major differences that we've seen in recent actions compared to before. And those have to do in part with Russia focusing seemingly on the US. In the past, although there have been points of seemingly attempts, Russian attempts at election manipulation in the US, David Remnick in part had written about the 1982 decision by Yuri Andropov to try to deter the re-election of Ronald Reagan. Since Reagan was re-elected in 49 out of 50 states, that was not an effective operation. But we've seen Russia using tactics like this usually in smaller countries. So this is nothing new, and to say Moldova or Estonia or Lithuania. Many of these countries talk about how they've faced issues of fake news, of NGOs being set up, and that this is something that they've seen many times. But it's something in which, to the extent that we've seen it seemingly in the US, is something that is somewhat surprising because Russia had usually acted in a slightly different way with other larger powers. The other thing that's different here has to do with the use of social media. So just to mention a couple of numbers here to keep in mind. Those who are tracking back how this has been done look at the Internet Research Agency, which seems to have been a Russian front that bought up Facebook pages, that bought ads, and used Twitter and so on. We're talking, the recent numbers that came out in congressional testimony and elsewhere were that there are about 3,000 ads that have been found on Facebook, coming from 470 different accounts. 80,000 pieces of content were generated. 126 million people saw these results, both ads and fake accounts. On Twitter, we're looking at something like 2,700 accounts that were linked to the Internet Research Agency, about 36,000 Russian bot accounts, about 131,000 messages that were generated. In Google, 18 different YouTube channels, 1,000 or more videos. So one of the things that's going on here is that the techniques in which information operations can be undertaken have expanded. So why is this different? 3 sort of main points here. The first is, as I mentioned before, that there are many reports that there's a sense in Russian leadership of sort of renewed, if not conflict, then at least heightened competition with the US. This is in part, and this is something we can talk about more in the question and answer, this is in part out of a sense, particularly by Vladimir Putin and those around him, that the color revolutions of about 10 years ago were really largely a CIA operation. That is, the US views that these were grassroots changes that were taking place throughout the former Soviet Union for more democracy. It was something that we wanted to assist and that we liked, but it was something that was viewed as being very much an open process of democratization. Many have written about a sense in Russia that this was actually something that was a CIA plot, and that the response was, well, if we don't like it when you do that to us, how would you like it if we get that back. So there's a sense of, once again, that Russia was being put on the defensive by those around Russia. Second is, as I mentioned, there are these new easy levers of power in terms of disinformation. So the way to think about it is this. The modern use of social media is to information operations what word processing is to, say, a typewriter, or even better yet, is just using some type of slate with a piece of chalk. You're able to do many more things much more easily and change them on the fly than you were before. So one of the key changes is that the tools that we have available, or the tools that are available, are much broader. So let me say a couple of words about those tools, and then I'll wrap it up here. So what about social media makes disinformation so much easier? Well, think about what you're able to do. You're able to have targeted marketing campaigns in social media. You're able to choose who gets your message. This is not a flaw of these companies. This is a feature. This is what they market. And in doing that, and having something that is targeted to particular groups, that also means that if you are not part of that group, you don't see it, which means it's difficult to track when there are psychological operations that take place, because you might never see them if you're not part of the target group. By contrast, on the flip, you allow for easy widecasting. You no longer need to go to a newspaper to publish widely. You can do it via social media. So you can both go very narrow if you want, and go very wide. Anonymity is once again something that is, for many of these platforms, a feature, not a mistake. So it makes it difficult to track back who originally had made these things happen. And ultimately, it's important to keep in mind that what we have as a result are things that happen in real life. So to take one example, this was as reported by Wired, but this is from a back and forth with Senator Richard Burr of Texas, where there were two different articles, there were two different sites that were set up about two different groups. One that was against the Islamization of American law, and the other that was in favor of Islamic rights. They were both set up by Russia, and they both called for rallies on the same day, same time, same place, which happened, and led to altercations. So this is an example of some of the real life results that you can have to use of information operations. What I'm going to do is I'm going to stop here, and during question and answer, we can talk a little bit more about the role of law in relation to this. But the main underlying thing is that we're going to need to think about some aspects of US law, some aspects of what companies can do to deal with these issues, and finally, third, is I'll talk about some of the things that each of us can do as citizens in terms of how we interact with it.
I'm going to talk about the investigative process that Robert Mueller heads and how that relates to the congressional inquiries, which are parallel investigative proceedings. To set that up, though, I want to tell you about how the world used to work back in the days before there was an independent counsel law, which you know a little bit about and which I've worked under one manifestation of, in the days when Philip was in the Justice Department and long before that, if you will. Law enforcement is an executive responsibility. The Department of Justice, of course, and the FBI as a law enforcement component within it has statutory jurisdictional responsibility for federal criminal law enforcement. And also, related to the topic that we're here to discuss today, parallel non-case building, non-law enforcement responsibility of a counterintelligence type. So in original structural form, all of that was within the executive branch. And all of that, to some degree, was in play during Watergate, which worked out well, if I may, but maybe sort of accidentally and magically, because there were different things that happened, including taped evidence, that removed ambiguity and allowed a divided political culture to reach a kind of clarity and consensus. After Watergate, in an effort to institutionalize more insulation, better protections for the chances of a high-level White House-involved investigation proceeding without interference or without compromise, Congress passed the Ethics in Government Act in 1978. One component of that was what we call the Independent Counsel Statute, which many of you have read about in the context of the Morrison versus Olson decision, which in 1988 upheld its constitutionality. The Independent Counsel Statute was basically an attorney general triggered system to get these president and inner circle people matters out from under the president's direct control. So instead of president, attorney general, prosecutors, FBI agents investigating president, which obviously has the potential to be quashed and compromised and restricted by executive supervision, the independent counsel statute allowed somebody outside to take the primary investigative responsibility. The system was complicated, but generally the attorney general would ask, a court would find a suitably experienced, available, willing lawyer. That person would become the independent counsel. That person would do the investigative work with staff, with agents. If crimes were found, would prosecute, would finish the work, and would go out of business. So regular law enforcement and DOJ, but kind of alongside it, a little bit insulated from it, mimicking it, but not under it, the independent counsel system. And this was a 5-year statute. It sunset after 5 years, but it was renewed 3 times. So it existed for a period of 20 years. But by 1999, each side of the political aisle, if you will, felt that this device had put its party and its presidents through a ringer of unjustified intensity. And so the law was allowed to expire. That means since 1999, we're back to just the regular old executive branch, the Department of Justice. And in that year, DOJ promulgated regulations, intra-DOJ regulations, providing for the appointment of special people inside DOJ, special counsels, to take over matters that need to be handled specially. And it's pursuant to that regulation that we have Robert Mueller doing the job he has today. The events of earlier this year, you all know generally, we've all been living through it, but generally the president takes office, and then the president fails to form a deep and lasting bond with FBI Director Jim Comey. He sends him out onto the street, unemployed, fired, and shortly thereafter, the Deputy Attorney General, who's functioning as the acting AG because the AG is recused, because he was heavily involved in the Trump campaign, and this is about the Trump campaign, the Deputy Attorney General uses the regulation to appoint Robert Mueller. Robert Mueller is one of the most experienced, universally well-regarded people in federal law enforcement, a former U.S. attorney twice, former head of the criminal division, former director of the FBI, no more ambition, Vietnam service, it's just perfect. Actually, in this brief time period post-Comey, when people were noodling around about would there be a special counsel who should be appointed, Mueller was the first name on my mind and a lot of minds, and I didn't want to utter it to anybody because I didn't want to contribute to the name being in the newspaper, which might jinx it or cause it to be discarded. So Rosenstein appoints Mueller, and Mueller takes over, according to the terms of the special counsel appointment, what Comey had been in the middle of. It's an oddly framed order that Rosenstein signed on May 17th, because it references public testimony that Comey gave, describing what the FBI had been up to before Comey was fired. So it is alleged links or coordination between the Russian government and individuals associated with the Trump campaign, and matters that arose from or may arise from that investigation, and any other matters within the scope of the special counsel regulation, which is efforts to obstruct and to lie to that investigation. What Comey and the FBI were doing was much more a counterintelligence investigation than a criminal investigation. It might have had criminal investigations, but as Comey described it, it was primarily figuring out what the Russians had been up to as an intelligence operation, so that we could assess what to make of that in our intelligence and national security interests. What I think unwittingly, and probably entirely unwittingly, President Trump did by firing Comey was put right in that description a criminal investigation. Because right alongside what's Comey's investigation of intelligence matters doing, we now have Mueller having jurisdiction over what was Trump doing when he fired Comey. And that's a criminal side, potential obstruction of justice question. Lots of things have sort of developed from that. You're, of course, aware of the Manafort and Gates indictment. and the plea of Mr. Papadopoulos and his cooperation with Mueller, and press reports about many other investigative trails that are being pursued. All of that is the executive branch work. Alongside it is the legislative branch work. That is not criminal law enforcement, that's government oversight. And it's being conducted in both the Senate and the House in the intelligence committees, which are permanent standing committees in each House of Congress, created in the 1970s, growing out of the Church Commission investigations, which revealed a lot of intelligence agency misconduct and things that weren't known to Congress. So since then, Congress has had these oversight committees. They have the compulsory powers of subpoenaing witnesses, if they so choose, to grant immunity to witnesses, to override their implications of the Fifth Amendment, to gather evidence and information. What they're trying to establish is facts for oversight of government rather than a criminal case. And sometimes that focus can run afoul of or collide with a prosecutor and FBI agents trying to investigate crime to determine whether to prosecute. We haven't yet seen that, mostly because I think these intelligence committees aren't extremely aggressive. Of course, they're not doing much public hearing, they're not doing much subpoenaing, they seem to have granted no immunity, and generally their public statements are about deferring to Mueller. So although in regular times or in past investigations, the congressional process has the ability to sort of supplant, take the lead, complicate the life of a criminal investigator, that isn't happening. We have a criminal investigator and also a counterintelligence, espionage, etc. investigator who really has the lead and really has, according to everything we're seeing, a fair amount of early momentum and a fair amount of interesting matters on his plate. I think it obviously and directly resembles a few predecessors, the one I worked for, Lawrence Walsh, but even more so the ones that Philip worked for, Archibald Cox and Leon Jaworski. So I'm going to be quiet because I'm dying to hear what he has to say.
Thanks, Dr. Philip?
I'm good.
Absolutely, yeah.
I used to be a courtroom lawyer, so I'm more accustomed to standing up and chatting with people rather than sitting at a table. A couple of the things that I'm going to talk about today dovetail with both of my colleagues who mentioned. I'm going to give you a little background on Watergate, and you probably all heard something about Watergate, but it is in that period of American history that's perhaps too recent to be considered history, but long enough ago so that it's not current events. So you may not exactly have an idea of what was going on that ultimately led to the resignation, the only resignation in American history. Watergate, like perhaps the Russiagate investigation, grew out of something that may turn out to be unrelated to what ultimately emerged as the undoing of a lot of people. And that may be, as John was saying, what happens here with the investigation that Bob Mueller is now doing. It was originally an FBI counterintelligence operation. What were the Russians doing, trying to interfere with our election? Were they trying to interfere with our election? It has now morphed into something very different. It's a criminal investigation into the activities of people around the president's campaign and around the administration now, including some of the president's closest advisors and even his children. So what may ultimately emerge, as illustrated by one indictment recently and one guilty plea, is a series of criminal charges that are different from the original focus of the counterintelligence operation. And in a sense, that's what Watergate was. Roll back. Anybody know what Watergate refers to? In recent history, every scandal has had the suffix "gate" attached to it. What is it?
It was a hotel.
Okay, Watergate. There was a Watergate hotel and a Watergate office building, but the hotel was more famous at the time. So it all emerged from a politically motivated break-in, at least that's what everybody assumed, at the headquarters of the Democratic National Committee. Sounded a little bit like hacking the emails of Hillary Clinton and the DNC in 2016. Well, this happened during the 1972 presidential election. And the clumsy burglars who broke in were immediately arrested on the scene. And they were referred to in the politically incorrect term as the Cubans. That they were all Cuban Americans. They had fled Castro's regime. And the fact that they were Cuban Americans and were identified as the Cubans turned out to have some significance because they were in a shadow world in the intelligence community. Nobody quite knew why they were breaking into the DNC. They weren't politically active. They weren't, as far as anybody could tell, volunteers with straw hats and balloons campaigning for President Nixon. But further pressure from the trial judge, Judge CICL, using perhaps an excessive and controversial degree of pressure as the sentencing judge, convinced them and the man to whom they reported that they ought to begin cooperating lest they serve really long prison sentences in federal prison. So the trial judge leaned on these men, and the man for whom they worked, and James McCord, to fess up and begin cooperating with the local U.S. attorney to figure out what was behind this. These people obviously weren't just breaking in, they weren't going to be stealing typewriters or the equivalent at the time. But they didn't know much about what their assignment was. But Judge CICL, who often got things wrong on the law throughout his whole career, had a kind of gut instinct, having been a local criminal defense lawyer and having sat as a trial judge for many years. He had a gut instinct that there was something more to this than just, as the president's press secretary termed it, a third-rate burglary. And the process went on. The Senate decided right before the election that there was something that needed to be looked in here. And there was, at this point, Democratic control of both the House and the Senate. And this is the opposite of the situation we face today, where you've got a Republican president and Republican control of both houses of Congress. Back then, Richard Nixon, detested by many on the Democratic side, was confronting a hostile legislature. And the Senate created a select committee, as John said, to conduct a parallel and public legislative investigation that tracked what was going on by the federal prosecutors in the U.S. Attorney's Office. As a result of some of the public disclosures, including the testimony of the president's former counsel, White House counsel, John Dean, it became reasonably clear that there was some kind of White House involvement in this break-in, and more significantly, White House involvement in a cover-up, trying to keep the actual burglars, the Cubans, from cooperating with the investigators by such things as paying them and their families hush money, bribe money, and inducing them to commit perjury before the legislative committee and the grand jury. Because of uncertainty about whether or not the regular U.S. attorney in Washington had the independence necessary to conduct a vigorous investigation, that, according to some of the testimony, would lead all the way to the president, not just to the president's senior aides in the White House. The Senate demanded from the man who was being considered to be the new Attorney General a commitment that if he was confirmed, he would appoint a special prosecutor who would be assured of independent authority to conduct the investigation and to follow the evidence wherever it led. He selected, the Attorney General was Elliot Richardson, of Boston Brahmin. He appointed a colleague of his from Boston, Harvard Law School professor named Archibald Cox. Now, Cox seemed to be an odd choice at the time. Unlike Bob Mueller, who, as has been mentioned, career in law enforcement, both on the investigative side and on the prosecutorial side. Cox had been a professor of labor law at Harvard Law School. So it would be hard to think of somebody who came with fewer credentials to lead a sensitive criminal investigation than Archie Cox. In addition, making this even more bizarre choice, Cox had served as Solicitor General. As you know, that's the chief representative for the government before the Supreme Court in the administration of John Kennedy. He was very close to the Kennedy family. Everybody knew that the Kennedys hated Nixon, Nixon hated the Kennedys, and so you had in office then, giving a lot of cover for the Republicans and President Nixon, a man who could easily be attacked as a partisan hack, but a partisan instrument, trying to undo the election in 1972, in which Richard Nixon, even after the discovery of the Watergate break-in, had been overwhelmingly elected. I think he won by, at the time, the greatest electoral college victory in American history. And so, just as you're hearing today with President Trump saying all of this Russia investigation is an attempt to delegitimize his election, and he keeps saying inaccurately, as with everything else, he had this tremendous electoral victory, and it's only a Democratic stunt to try to undo the legitimacy of his overwhelming, in quotes, election. So too, during Watergate, the Republicans who were supporting President Nixon could say, look at him, he was just elected by this overwhelming majority, and yet we have, heading up an investigation, a man who is a veteran of the Kennedy administration, a close friend of the Kennedys, and presumably a Democrat to boot. After Cox was appointed and was beginning his staff up, I was appointed as his counsel, which carries with it responsibility for all of the legal issues, legal and constitutional issues, and that's how I became involved in issues such as whether the incumbent president is subject to indictment. Is there such a thing as executive privilege, the issue that went to the Supreme Court in the Nixon tapes case? If so, is it an absolute privilege or a conditional privilege? If it's only conditional, when can it be overridden? As the case unfolded, I don't want to go into too much detail, the key element of what ultimately unfolded was the concession by one of the staff people in the White House that the president had been recording all of his conversations in the Oval Office. The stunning announcement before the Senate Select Committee was, there's tape in the Oval Office. That then led us to consider, should we try to get the tapes from the president? Archie, the special prosecutor, said we promised we were going to go wherever the evidence might take us. This is material evidence. The president denies that he was involved in the cover-up. John Dean, his counsel, said he was involved, or at least was briefed on the existence of a cover-up. And now we know that the conversations that Dean said took place were recorded. How can we not pursue the evidence? So, that subpoena, I went over to the White House, took the United States Marshal with me, because we knew what was going to happen. I served the subpoena, and fast forward, the president says, I'm not going to comply. You're just an officer of the executive branch, a subordinate officer of the executive branch. I'm the president. The Constitution says all executive power is vested in a president of the United States. I decided that in the interests of the presidency, the office of the president, I must protect the confidentiality of communications, and I owe it to my predecessors and my successors to decline to comply with this subpoena, and I instruct you, Special Prosecutor, not to proceed any further. The Special Prosecutor proceeded further. Both the District Court and the Court of Appeals said the President has to comply, and then the President said to Cox one more time, I direct you not to try to enforce the court order Cox and the staff reviewed. Cox decided at the end, after considering whether it was responsible or irresponsible to set up a true constitutional crisis, as was then foreseeable. Should I enforce the court order, triggering perhaps a Supreme Court decision, which could go either way? When we were counting votes, we thought we could count on 5 votes in the Supreme Court. But Cox, being a law professor, could deal with the hypotheticals in both directions. Let's assume, he said, that the Supreme Court upholds our power to do this, and the president defies the court. We would have precipitated a direct constitutional confrontation between the judicial branch at the highest level and the head of the executive branch, with consequences that were unknowable. Suppose the court comes out the other way and says, no, the president doesn't have to supply evidence. Unlike every other person in the country, the president doesn't have to supply evidence when demanded by a grand jury. Would we then have demonstrated exactly the opposite proposition from the one that we were trying to demonstrate, which is that no man is above the law, even the president? And so there was a great philosophical and political in a nonpartisan sense, conundrum that was discussed before Cox said, Mr. President, I cannot obey your instructions. I insist that you obey the order of the court sustaining and enforcing the subpoena. Cox was then fired in the so-called Saturday Night Massacre, which changed the political calculus dramatically. At that point, another congressional body, the House Judiciary Committee, got involved in the process and began an impeachment investigation. The impeachment investigation then went on in parallel with the Senate Select Committee. The firestorm, as General Haig, the President's Chief of Staff, announced it, was so intense that the President, within a week, was forced to appoint a new special prosecutor, Leon Jaworski. And this time, thanks to a lot of pressure from within the Congress, the new regulations that accompanied the appointment of the replacement special prosecutor were more protective than the ones that John just mentioned that are currently in the Justice Department regulations. They said specifically the special prosecutor may not be discharged except for gross impropriety, and the determination of gross impropriety must be made personally by the Attorney General, not by the President or anybody else. And the special prosecutor is entitled to pursue any evidence that he chooses to pursue. So we had what turned out to be a very significant, and I think probably not well appreciated at the time, additional fillip to the protection of the independence and power of the special prosecutor. As it turned out, when the first group of tapes was disclosed, the President had been up to his armpits in the original cover-up. There was never any evidence that he had approved the initial break-in. That was done by the President's re-election committee. But the President, when he was told that the FBI was sniffing around, said to one of his senior aides, why don't we call the CIA and tell the CIA to call the FBI and say, you're monkeying around with a national security matter, back off this investigation into the responsibility of the actions by the Cubans, so-called. And here we later learned that the Cubans were part of a national security operation. They were part of the so-called Plumbers operation. Called the Plumbers because President Nixon, like every other president, got hysterical about leaks from the White House or the Defense Department about national security matters. So the Plumbers, led by a couple of other people, including a man named Gordon Liddy, who has remained a political commentator for the last 40 years, Their job was to investigate the people who might have been responsible for leaks, including the leaks of the Pentagon Papers. And you may have read the Pentagon Papers case, constitutional law as well. So the Watergate investigation evolved from just a third-rate burglary into a cover-up investigation and into a Fourth Amendment civil rights violation, because it turned out that the plumbers were involved in illegal break-ins at various premises in an effort to find out who was responsible for the leaks of classified information. And somewhat bizarrely, a break-in that led to the indictment and imprisonment of some other people took place at the office of the psychiatrist of the Defense Department official who worked on the Pentagon Papers and who had been the source of the leak to the New York Times and the Washington Post. All of this began to emerge from the first round of tapes that we got during the grand jury investigation. We then indicted the President's Attorney General, Chief of Staff, White House Counsel, head of the National Security Division, Justice Department, and issued additional subpoenas, filed subpoenas. Again, the President refused to comply. That's the case that went to the Supreme Court. And in those subpoenas, we had the advantage of additional information that had been developed in the ensuing 6 months since the first round of subpoenas, since the Saturday Night Massacre. And we identified 7 conversations on specific dates that John Dean had said were ones that were most important in his briefing the President about the cover-up, and that we thought involved conversations involving the President and people other than Dean, the people who were really central to the cover-up investigation, the President's Chief of Staff, Haldeman, and his counsel, John Ehrlichman. So we had a new series of focal points for the next round of subpoenas, and it was understandable why the President didn't want to comply with those orders either, because those turned out to include the so-called smoking gun tape, in which the President very explicitly was briefed on what was going on, very explicitly gave the instructions for the cover-up. He was told that it might take $1 million to pay off the witnesses, including Cubans and their families. And he said, that's no problem. We can get $1 million easily from his supporters. The case ultimately went to the Supreme Court, and I'm bore you with what I thought was the intriguing procedural mechanism, intriguing and I'd say creative procedural mechanisms that we used to get the case to the Supreme Court when and as we did. And Leon Gorski and I divided the 3 hours of argument, and the court, as you probably know, somewhat to our surprise, came out 8-0 in favor of the existence of a qualified constitutionally based privilege, but one that could be overcome, the court said, by the showing that we had made that this was crucial evidence necessary for a fair prosecution to determine guilt or innocence. And what we argued was, we don't know what's on the tapes, we suspect what's on them, but if what Mr. Dean has testified is false, that might exonerate the defendants, and the judicial system has an equal interest in exonerating the innocent as well as convicting the guilty. The tapes, including the smoking gun tape, once made available to some people in the White House to listen to, led the White House, General Haig, notify some of the President's supporters in the Senate that he did not have a defensible case against impeachment, which the House was about to vote, and they put pressure on the President to resign. So within 2 weeks of the time that the Supreme Court decision came out, the President left. First time in American history that a President left office voluntarily. Left under more lethal conditions. Different matter altogether. But you you see, there are some parallels here. There's an intersection between national security matters, as there was in Watergate, and the Russiagate matter. The crimes that tripped up more of the people were not the initial focus, but were the cover-up charges. I think that's likely to be the situation with General Flynn, Mr. Stone, a variety of other people, conceivably the president's son-in-law, at least one of his sons, other than General Flynn's son. So I think that as the Mueller investigation unfolds, what you will find will be the latest example of the truism that it's not the original offense that's so bad, it's the attempt to cover it up. This is something we learn even when you have teenage children, perhaps when you live around your former teenage friends. When you get caught, lying only makes it worse. Well, the same thing's true in the criminal law. Apart from murder, almost any other crime gets complicated and becomes a more severe exposure to punishment if you compound it with perjury, obstruction of justice, such as trying to fire the prosecutor, or trying to give false testimony to the FBI, which seems to be almost an epidemic in this sad affair. So how this will actually turn out, I don't know. I was asked recently by the editor of The Atlantic whether his instinct was one that I agreed with, and that is that the Russiagate is more important than Watergate. And I said, I think it is in a very real sense, and it's what Professor Logan and John have both said. The underlying conduct here involved the efforts by a hostile power to decide who is going to be our president. In Watergate, it all started out with an attempt to determine whether a Democrat or a Republican would become the president, but it was kind of an internal dispute. It was an American-only dispute, if you will. The current investigation that's underway involves an attempt by a hostile foreign power to decide that one candidate versus another was, in the view of their intelligence services and their political leaders, likely to be more favorable to their strategic interests in Eastern Europe, in the Crimea, in Ukraine, than the other candidate. And I think that will ultimately make whatever happens here a more, if you will, ominous and perhaps more significant affair in American political history, even than Watergate, although I certainly would not want to minimize the importance of Watergate. Otherwise, I wouldn't be here this afternoon.
Maybe I'm going to start the comments and encourage some of the panelists to chime in, and then we'll open it up to the floor. On the last point, and that is one area that hasn't been covered yet, which is where does the foreign interference come together with potential criminality of members of the Trump campaign and those in the White House? And I think particularly focus on General Flynn. So we have, this is a handy guide for those who came in late of all the players. So Michael Flynn serves as an advisor, early advisor to the Trump campaign, while at the same time being subject to the kinds of personal intelligence ops that Professor Morgan mentioned in the approach that Russia's take to influence thought leaders and powerful people in foreign governments. Oh, yeah, sorry, yeah, no, I don't have the copies.
Oh, thank you.
Yeah, you got them all from that. So he's involved with the Russians paying him. He also, it later turns out, is being paid by the government of Erdogan, Turkey, to actively promote a theory of culpability. I'm going to say a theory of culpability in air quotes about the coup in Turkey, and in particular the position that Erdogan has taken that Mr. Gulen, who lives in the United States, under the protection of U.S. law, is responsible for the coup and therefore should be extradited and rendered to justice there. And his son is also involved in that business. Importantly, this gets to the issue of cover-up and lying. He doesn't disclose any of that in all the required disclosures once he's the national security advisor. there is a law in the United States, the Foreign Agents Registration Act, which is, it's not a law that gets enforced very often because its purpose is disclosure. So if you retroactively file and you disclose and there's transparency, it's usually not problematic. But you will note that in the indictments that have come down, that failures of full disclosure in the case of Mr. Manafort and Mr. Gates were included in their indictment counts in the bar. So that's Flynn is number one. Number two is, I think is sort of the elephant in the room perhaps, is the idea that the president himself was targeted by Russia in his visits to Moscow in 2013, and the so-called dossier of information of compromat that may or may not have been collected on him. So Flynn and compromat, I throw that out for the panel to discuss.
Well, Flynn is obviously key to the whole investigation. He was a major part of the president's campaign. You may have seen at some of the rallies, General Flynn, in what I think must have sent shivers down the spine of many career military officers. The president, General Flynn, was out there sort of glad-handing and just extolling the virtues of candidate Trump in a much more politically aggressive than most retired general officers would feel comfortable doing. He was viewed as a senior national security advisor. He had been the head of the Defense Intelligence Agency as a three-star general, although he was fired during the Obama administration, fired by the Secretary of Defense, because he was regarded as irresponsible, insubordinate, and just a loose cannon, which is, you wonder how he got to be a three-star general and the head of the Defense Intelligence Agency with all those character flaws. But nevertheless, that's where he was. But Flynn would know, based upon what's now become clear about his role in the campaign and the contacts that you mentioned with the Russians, what sorts of overtures were being made by the Russian representatives, either directed by government agents or more likely through cutouts or intermediaries, in order to try to influence President Trump or the closest people around him, including Donald Jr., his son, who received one of the famous invitations to get some dirt on Hillary Clinton and then set up a meeting to try to see what that dirt would consist of. So Flynn is a key person, and what's significant about the mechanics of a criminal investigation is that he seems to be caught dead to rights with respect to not only the false statements in his Foreign Agents Registration Act and other government security forms that had to be filled out, but also dead to rights lying to the FBI. And although it was a relatively surprising development to many people in the criminal law field, the statute that prohibits false statements to an agency has been construed to mean even giving false information during an FBI investigation. So you don't have to be under oath. The original concept was if you're being interviewed but you're not under oath, such as before a grand jury, if you're not telling the agents the truth, that's not a federal crime. But now it's identically the same penalty as for perjury. Almost certainly Flynn has committed several violations of that statute as well as the Foreign Agents Registration Act. So he faces hard time, and his son, apparently, who was involved in his business, also appears to be vulnerable in this way. And the speculation, which seems to be quite plausible, is that Mueller and his team, very expert and experienced prosecutors, are leaning on General Flynn to cooperate in order to preserve some opportunity for his son not to go to prison or not to go to prison for a very long time. So the question is, will Flynn be a stand-up guy? Will he protect his son, or will he protect the president? And time will tell.
One thing that I'll add to answer the question, not focusing on General Flynn, but on sort of this question of what can you see in terms of activities and possible collusion. one thing that came out in the testimony of sort of internet intermediary, Facebook, Twitter, Google, they testified before various committees to the House of Representatives and the Senate about a week ago. And one of the lines of questioning which I thought was very interesting, and which has been noted by various media outlets, was a lot of questioning having to do with Twitter and tweets, which so much in this presidency seems to come back to Twitter and tweets. But this was having to do with the campaign and the timing of certain tweets that came out from the campaign on specific issues. One example had to do with tweets having to do with Hillary Clinton's health, and how there were also tweets at very close to the same time that came out from Russian government outlets. And so the question that was coming from the representative who was asking this, and this was a question that was going to the internet execs. This wasn't to members of the Trump campaign. But it was a question in terms of tracking and whether or not the types of things can be tracked, and what's the type of information that's held in terms of the timing of things and the source and so on. And so I just mentioned that as one of the issues that at least some people seem to be asking, which is, in this question of information or disinformation, was there any coordination in terms of the messaging that came out from the government of Russia? Specifically, this was RT Russia Today, which is a Russian government outlet, and the Trump campaign. Whether or not that's something that comes back into the investigation, or whether it's something that stays primarily in the interest of Congress, I don't know. But I simply note that that is one of the aspects of it.
A footnote here, RT, which is a television station that has been on U.S. cable networks, and it's theoretically a news outlet that some American journalists went to work for briefly before finding out what was going on, has just been required within the last week to register as a foreign agent of the Russian government. So the U.S. government, with or without President Trump's clearance, has required that RT acknowledge reluctantly that it is actually an agent of the Russian government, not simply like CNN or even Fox.
Can I add one more thing on Flynn? The role he had sort of stretches back to the summer and the conventions and lock her up and so forth, but also pervades the fall and a transition period. And, obviously Mueller is a very appropriately buttoned-up operation and isn't leaking. But the contacts among and between the campaign and then the president-elect in his transition and Russians, including Ambassador Kislyak and other operatives, and then the Justice Department before the inauguration when Sally Yates is the Deputy Attorney General, and she, knowledgeable about what intelligence reporting is showing about Flynn activity, is in contact with the White House counsel, or about to be White House counsel, and then the new White House counsel, and the Vice President, and the President, and so forth. So there are a lot of players that are potentially radiating out of what General Flynn was doing across those 6 to 9 months.
That leads to my question, which, so Philip, you said earlier, it's, the cliche, it's not the crime, it's the cover-up. So the question of all of these contacts, potential, let's assume coordination, let's assume all these contacts happened during the campaign and during the transition. So we have one statute called the Logan Act that says it's illegal for private citizens to carry out foreign policy. Enforced twice, I think, in the whole history of the United States. So it's there, but Jimmy Carter goes out and practices diplomacy. No one's going to arrest Jerry Brown for being involved this week in negotiating climate change. Or maybe there is that, but there's a norm once the transition. So question number one for the panel: is it against U.S. law for a political campaign to coordinate information gathering with foreign government? Question number two, does that change during the transition? That is, there's a norm during transitions. It's not a law, but there's a norm that says there's one president at a time. And so typically when a new president is elected, we have that gap between the election and the inauguration. And there are lots of phone calls with foreign leaders, and they're generally just surface congratulations. We look forward to meeting in February and talking to you. But there's no substantive conversations because you defer to the State Department or to the White House. It's my understanding that didn't happen. These calls were picked up by counterintelligence folks at FBI, and the subject matter of those calls is also problematic. The question is whether it's illegal. Would it be illegal for a transition member to say, "Don't worry, come February, we're lifting the sanctions"? Is that violate US law?
Just say my successor several generations later from the SG's office has been brought over to Mueller's office. He was the deputy who was in charge of criminal matters in the current Solicitor General's office. He's now performing for Mueller the kind of function that I performed for Cox and Jaworski. He doesn't have the same title, counsel, but may not have the same title. But effectively, that's what he's doing. And he's analyzing exactly the issues that Peggy was addressing. We talked kind of loosely over the last year about collusion. Well, is that a crime at any point during the campaign or thereafter? And the answer is, well, not as such. There's no crime of collusion. But there are other crimes that are in the picture here. Computer hacking is a crime. It can be a felony. Conspiracy to encourage that sort of activity. When you need not get to President Trump's campaign statements. I love WikiLeaks. I love the Russians. I love hack into these emails. Even below that, at a more clandestine and furtive level of the sort that's suspected, there may have been a conspiracy to engage in improper activity. On the question of when contacts with a foreign government become questionably illegal, possibly illegal, there is a general federal conspiracy statute that some of you may have studied. It's Section 371 of the Federal Criminal Code. It makes it a crime to conspire to violate other statutes. Okay, that's pretty easy. But then it has a branch in there, conspiracy to defraud the United States, effectively, the courts have interpreted, to defraud the United States of the proper performance of governmental functions. And that's where you get into an area where some creativity on the part of Mueller's legal team may be able to develop a legal theory that at some point, when you're operating to seek the assistance of a foreign power, at least a hostile foreign power, to participate in electoral activities, or you're asking the foreign power to refrain from certain actions that, or to take various actions either way, that are inconsistent with the current position of the United States government as articulated by the incumbent president, Obama, there you might have a federal conspiracy to defraud the United States violation. So there are very smart people who are looking into exactly these issues.
Can I ask one follow-up question? And maybe John knows the answer. What's the definition of treason? What does the treason statute require?
Treason's in the Constitution. Treason is being comforts 10%
To an enemy, but I think that's generally been viewed as in wartime.
There has to be declaration.
Or some sort of combat activities. At the moment, we have a Cold War, but I think no one would use the treason statute as such. There are other statutes that involve espionage, violation of signals intelligence procedures, and so forth. So it's hard to know what the litany of possible criminal charges will be because, as you know, from my experience, it's kind of an iterative process. What sort of facts are we developing? Okay, do they fit within the rubric of any criminal law? Well, what are the possible criminal statutes? Should we be looking for facts that support it? So that's the way this sort of complex investigation unfolds. It's really like a big, complicated combination of a white-collar crime and an espionage case.
Just on the conspiracy point, bringing my telephone book to class today. This is the Federal Criminal Code. And 371, conspiracy to defraud the United States, is a capacious statute that often, through that kind of iterative process, can be applied to facts that investigations develop. And Mueller has already used it that way. The indictment of Manafort and Gates includes 371 charges, conspiracy to defraud the United States, which some breathless reporters thought was a treason charge. It's conspiracy to defraud the United States of its entitlement to honest compliance with the declaration of foreign bank accounts, which they're charged with not doing, and with proper registration as foreign agents, which they're charged with not doing. So what the government in ordinary legal landscape is entitled to, if people don't perform properly and obey those requirements, can be an object charged as a violation of the conspiracy statute. So that's a potentially sizable hook of grounds for prosecution.
A couple of quick things I just want to say on this is first, really picking up on the main points that folks had said, that in terms of some broader things like, say, the Logan Act or the Espionage Act, those are some of the bigger ticket issues, and it might be that that's not how people choose to go forward with any types of cases having to do with this, because you have specific acts. And the couple of things to think about is really along the lines of what he said. Was there at any point someone from the US asking for hacking or something like that, which in and of itself would be a crime? Those are the things that are more specific and more provable, and things which have a longer track record in terms of its use in the courts. So that, I think, would really be the sort of areas of focus in this. Even though it could be, even if an act hasn't been used many times, there could always be an attempt to try to use it now. But there are possibly ways that are a little bit more definite and more sure in terms of if they're able to prove specific acts.
I think that's a very important point, because in a politically sensitive investigation like this, where you know that there are already a lot of people who are supporting President Trump and his administration who are alleging that this is all fake news, fake investigation, it's a political witch hunt, it's whatever. The more orthodox the crimes that you can allege, the more credibility and integrity the outcome is. If you have to stretch too far, then it looks as if you have a result you want to reach and you're trying to manufacture some plausible justification for it. I think Mueller and his team are sophisticated enough in the ways of Washington to be sensitive to those considerations.
That's great. I'm going to open it up for questions from the students. So I'll keep the queue and call this.
So if I'm at FSB or GRD, my concern is to have U.S. law. Ideally, I want to try and have U.S. law protect any operation that I can do. In what way, or would it be possible for a First Amendment claim to protect an effort of manipulative disinformation, in the sense that it's political speech, whether it's true or false?
To protect a Russian from being prosecuted.
Even to protect an individual, even a foreigner in the United States, running a Facebook page where he, sends out fake news. That's political speech. Would that be protected?
So this is an argument that has come up in recent cases, which is that if something was being done if something was within sort of the First Amendment rights and these were usually Americans who were being prosecuted, the question was whether or not the First Amendment rights, whether these things were done under the First Amendment rights, or whether or not they would be essentially acting as foreign agents. If something is political speech, then that is protected. The issue is if they were doing anything that was going beyond merely speech. And in those cases where the First Amendment argument is made, oftentimes they look to see the after, once again, essentially U.S. citizens were usually into this, and whether or not they were doing something that was going beyond speech. So were they also doing something like seeking to obtain information that was supposed to be secret? Were they doing anything like hacking or anything like that? At that point, that becomes something that is beyond speech. If it is simply something that is speech, right, then I mean, this would be a sort of a case of first instance. But the argument would be made that what they're doing is simply using their speech rights, and try to argue it based on some of the precedent that exists on cases with some slightly different facts. But
I would say one additional thing, which is the diplomatic response. You may recall, maybe you don't recall, that last fall, the Obama administration responded to the strong evidence they received by October 2016 of this Russian hacking and meddling by expelling dozens of Russian diplomats and shutting down 3 or 4 facilities, including a facility that was known to be an intelligence facility. And that's one of the, it's a tool that you have when you don't have the force of a subpoena that you can enforce in Moscow against the people who are running the operation. So that's a political tool, not a legal tool.
By the way, I should just add, in the way that you sort of frame the hypo is if you're framing it as someone who's in the U.S. and is actually a member of a foreign intelligence agency, that's also different than the facts of the case that I was talking about, where we're talking about U.S. citizens who are undertaking activities. Because if it's a part of a foreign intelligence operation, that is, you are part of a foreign intelligence agency, it's probably much easier to do something like the Espionage Act at that point. And it's not sort of a First Amendment issue, but that's simply, foreign spies in foreign countries are basically treated as criminals. So that would be something that would probably be much easier to.
But if they're not covered, they can't be prosecuted, so then they get kicked out. So that's how they have diplomatic immunity under that.
And of course, if they're outside the United States, the existence of a First Amendment privilege to send false information, even of a political nature, into the United States is probably minimal. So the narrowest reading of your hypothetical is I don't think a KGB or SB agent can claim any First Amendment protection to disseminate false information into the United States, even if it's political in some sense.
Carol?
My question is actually, I'm interested in a little bit more about what you said in terms of the Watergate investigation, how the president's actions sort of or other people's actions to cover up actually made things worse. So I'm interested in paralleling to now, what is Trump doing, how is he interacting with the Mueller investigation? I know that you might have said some things to him like, don't make this go away, maybe something like that. I think that might have been reported in the media, however it was. But my impression is that he has some sort of interaction with the Mueller investigation. And then, so what's happening? What are the implications of that? And is he making matters worse for himself, similar to how it was in Mueller?
I think so. I actually did an op-ed in the Washington Post not long after Mueller, after the firing of Jim Comey, in which I said, this, to me, satisfies all of the prima facie elements of the kind of obstruction of justice. And we went through the details of the obstruction statute. And the defense side, that is the Republicans, particularly in both the House and the Senate, and the White House press secretary, said, well, obviously, Comey didn't desist. He didn't abandon the investigation of Mike Flynn, which was the focus of the president's comments. And as I explained, you don't have to be successful because the statute prohibits a corrupt endeavor to obstruct the due administration of justice. And the corrupt element is satisfied, in my view, by an improper motivation. Cases that say corruption doesn't involve bribery or something. It involves, as I would argue, a self-interested exercise of power. So the mere fact that the president, as chief executive, could oversee an investigation or conceivably could decide as a matter of law enforcement priorities what matter should be pursued and what not, I think is arguably a corrupt use of power to protect yourself, your family, your chief campaign aide, General Flynn, against the due administration of justice.
Kind of piggybacking on Caroline's question, actually. Considering the relative lack of regulation regarding the protection of special prosecutor in this case as compared to when you were describing Watergate, other than obstruction of justice charges, what protections are really in place here for Mueller, considering the fact that we have a president who's particularly adept, so it seems, spitting accusations when they're hurled at him in the court of public opinion, and considering the fact that both houses of Congress are controlled by Republicans, and maybe the legislative committees, as you described earlier, aren't necessarily there as a check on the investigation of the president as well as the reporter.
I think the main constraint is a political one, because John mentioned, the regulations and the order under which Mueller was appointed allowed him to be removed for misconduct or failure to satisfy or follow regular Justice Department policies. And just to drop a footnote here, one of the issues that came up in Watergate and comes up now with Trump in response to your question, is President Trump himself legitimately within the gun sights of Bob Mueller? Could he be indicted? We took the position and argued this to the Supreme Court that the president is indictable while still in office. He does not have to be impeached and removed before he's subject to the regular criminal law. The official position of the Justice Department, however, is that a president may not be indicted, at least may not be indicted by a federal grand jury while in office, although they're getting into very sophisticated analysis. So if Mueller tried to proceed down that path, and Trump and some of his allies have already begun to make noise about this, this could be a basis for alleging that he is going outside of his proper ambit of authority. But there are two political protections that I would say exist. One is that the Deputy Attorney General, who got burned by playing ball with the president in connection with firing Comey, offering up a fig leaf justification for that, then responded by appointing Mueller and has said he's the person who specifically would have to do the dismissal. The president can't fire anybody directly, it has to go through the chain of command. And Rosenstein said he would not fire Comey, Mueller unless he is personally satisfied that he's engaged in some misconduct. The other part of it, though, is a bit akin to the Saturday Night Massacre. A number of Republicans, maybe enough Republicans, have said they would not tolerate the firing of Mueller, at least unless there was a demonstrable case of some gross misconduct. So I think that's a kind of political insulation akin to the Saturday Night Massacre, because that kind of action by the president could change the calculus.
In between those two, Mueller not likely to make the kind of misstep that would qualify as violation of DOJ policy or something that would be valid grounds for dismissal. And some Republicans are already saying that they've got his back. They've got his back if the president tried to mess with them. Is Rosenstein, and I would bet a fair number of senior DOJ people who would refuse to carry out that order, who would resign in the face of that order. And then what that does politically, if the leadership of DOJ, Sessions is recused, Rosenstein and others resign in the face of an order to dismiss a prosecutor who doesn't deserve on the merits of the appointment to be fired, becomes a firestorm. And then, where's our politics? Where's the country? Where's the media? And where's the Congress? And I think that's what the president's more sober advisors are telling him, but, he's mercurial.
But that's another area where you've got a parallel with Watergate. I mentioned that Special Prosecutor then was appointed because the Senate had extracted a promise from the Attorney General that he would appoint a Special Prosecutor to give an end to independence. So when the President's Chief of Staff directed Attorney General Richardson to fire Cox, Richardson said, "I can't do that, I resign." They then directed the Deputy Attorney General, and he said, "I can't do that, I don't think that's legitimate. I couldn't do it." He was fired. The next person in line was the Solicitor General, Robert Bork. And Bork did discharge Cox. And his explanation was that he was concerned that if he didn't perform the deed, all of the other members of the command of the Justice Department, all of the Assistant Attorneys General, would have to follow suit as a matter of conscience or whatever, and that therefore the Justice Department would be denuded and that would be bad for the public interest. Now, I talked to Bork that the night of Saturday Night Massacre. He gave me that as his contemporaneous explanation. And I was actually willing to testify for him when he was being nominated for the Supreme Court, explaining that I thought that was a plausible justification for his executing the president's order to execute Cox. But it is a real issue about whether somebody, if Rosenstein were to say, I can't do this, and the task then fell to the Associate Attorney General, or the next title is now, whether that person would say, well, if Rod's not going to do it, I can't do it either, or whether they would adopt the Bork strategy, I need to do this to protect the stability of the Justice Department, and too bad.
Firstly, thank you for coming. Your insight is very unique and appreciated. Also, we discussed all the obstacles and different ways that this could be pursued. But let's say we find everything that we think is there. Let's say we find evidence that something occurred. What would be the next steps? What could be the outcome of that? What steps would it take to have any effect administratively of who stays in power, who does not? And then what obstacles are there in order to overcome it? Have an actual effect on the
Well, there's the debated question about whether a president could be indicted. You're hypothesizing we find evidence of presidential criminality.
Yes.
There's an argument that a president could be prosecuted. If not, or instead of, there is historical precedent of prosecutors referring information from DOJ to the House of Representatives for it to carry out its potential impeachment function. That happened in Watergate, that happened in the Clinton, Lewinsky, etc. matter. So if Mueller has that kind of evidence and doesn't believe he can seek a grand jury indictment, he might hand off the evidence to the House of Representatives. And then it's a question of the political calculation and will in the House, I think.
So I've been thinking a little bit about the president's pardon and how that might relate to this investigation. So in the special prosecutor's section, trying to pardon witnesses, people might be closer to the facts. Has a president ever used, or is there any evidence that, or any, can you imagine a scenario where
The answer is yes. I can't.
Been there, done that.
A year ago, a lot of things that couldn't be imagined are now imagined.
So, like, for example, the Civil Rights Department of Ohio, which is a controversial decision, could he use that, or could he with sort of a hint or indication that, like, he has this power, could he use that to sort of convince people not to cooperate? Is there anything?
I think your question answers itself, right? I mean, there are plenty of people speculating that the president is signaling in his tweets and in his actions to people he knows who may or may not be cooperating. I should say there was also some evidence in the press that there were actually conversations happening between Trump and Clinton after Clinton left the Office of National Security, which is just from a lawyer point of view. I get your clients to listen to when you say, these are the people you may not have contact with during an investigation. Some problematic conversations, I think, that will come back to haunt some of the potential targets here.
But Mary, I think there are 2 points I would make in response to a very excellent question. One is that the presidential pardon power is a governmental power, like other governmental powers. So the question is the president in exercising that power subject to the other strictures of law? For example, take the easy case. President, somebody walks into the Oval Office with a suitcase full of money, which I have not that he's on this election.
We'll circulate all your op-eds after this.
Sorry. Walks into the president's Oval Office and says, let's say it's Mike Flynn, and he's gotten $15 million from the Turks. Here's $15 million, Mr. President, pardon me and my son. Now, the president may be able to issue a pardon, and maybe it would be enforceable rather than voidable. I don't know. But it would almost certainly be a crime by the president to take a bribe. The obstruction of justice statute, in my view, equally applies. If you are, just as in the Watergate case where the president was saying, pay hush money, bribe money, to keep these witnesses from testifying truthfully about who else was involved, and that was viewed as prosecutor's office and by the House Impeachment Committee as a prompt by President Nixon. If the president is trying to use actually or as a bargaining chip, the pardon power to prevent somebody from being exposed to criminal prosecution or from testifying and cooperating in criminal prosecution, I can see without too much imagination that would be an offense. The other point that I would make is in Watergate, as you may know, after he resigned from office, President Nixon was pardoned by President Ford. He then, in the special prosecutor's office, had to consider the question whether the left open possibility of prosecuting President Nixon, at least after he left office, should we challenge the validity of the pardon that President Ford issued to President Nixon? And there's a memo that's been published that I wrote in which I set forth an analysis on which the effect of the pardon could be challenged so as to render it ineffective. So the pardon power isn't the end of the story here, is all I'm saying.
We'll take one more question, then I want to have folks have a chance to come up and chat. Yes, Zach.
Is there a question to raise in proposing some reflection on a policy that can be drawn to honor the discrepancy of the dismantled criminal investigation on both parties in the form of a negotiation imposing petitions?
We should have a bipartisan negotiation
Yeah,
about the political machinations that each party
Perspective.
is guilty of in criminal prosecution. Is that
yes, what I'm saying is,
Kumbaya Summit?
yes, is there some discrepancies on both parts opposed to just one party?
We're talking about the political parties here?
Yeah.
Oh, okay, so,
Focusing on 2016 and the campaigns?
No, I'm talking about the Mueller investigation.
yeah, so tell the scope of the investigation, yes, you can speak to that. The scope of the investigation, under the scope, would he be permitted, for example, to investigate, I don't know, things that Donna Brazil has talked about in terms of potential irregularities in the 2016 election, or the,
Maybe.
Yes,
What
can
is
it be, and to include, can it be negotiated, or can there be some kind of reform to, that can develop to,
for the future?
for the future, to address both sides, address both parties?
Two separate questions.
Yeah, the scope of the Mueller appointment specifies any links or coordination between the Russian government and the Trump campaign.
It does say the Trump.
I said the Trump campaign. So it seems focused in that direction.
Yeah.
I don't think there are any allegations of Russian Clinton, but it does seem focused in the one direction. The possibilities of statutory reforms are, of course, always desirable, and smart people are always thinking of good government innovations. We're not currently in a politics where we're doing much legislating at all.
Okay.
And certainly not on the kind of reform, good government, campaign finance, openness, disclosure, political campaign conduct, will of the voter preservation. We're not right now doing a lot of that.
Okay, Chris, how likely do you think it is that Twitter, Facebook, the whole question of Section 2030 of the,
So, on that side, so the internet, this is something right now that Congress, where there is some bipartisan interest. That's on a separate thing. A couple of the things that have been mentioned in the last couple of weeks includes issues of disclosure of when there are politically related ads, in terms of keeping track of where the money came from. As I mentioned, some of the ads are sort of targeted, and so a lot of people don't see them. So another thing that members of both parties have been talking about is requiring companies to keep an archive of all of those ads, including targeted ads, so that someone can go back and do research and find out what's going on. So that right now there's this discussion of, as some people have been saying to the companies, look, what you can do to sort of deal with these issues. Maybe you should come up with some best practices, otherwise we will step in to regulate. And that is one area where you do seem to find some interest from both parties in terms of thinking about what to do before the next election cycle.
So with that, first of all, I want to thank Mr. Lemavera coming to visit us in St. John's. Since you're a first-time visitor, you get a little St. John's keepsake, a really useful thing to let you discover. So thank you so much for coming.